Welcome back to the channel, guys. Let's get straight into today's story. There is one law that sits quietly behind many of Britain's biggest failures. From immigration enforcement to policing to deportations to national security decisions that seem impossible to carry out. It's rarely debated honestly, rarely challenged directly, and almost never explained properly to the public, but its impact is everywhere. That law is the Human Rights Act. When it was introduced, it was sold as a safeguard, a way to protect basic freedoms and bring rights closer to home. What it actually did was something far more profound. It rewired British governance, it shifted power away from elected lawmakers and handed it to the courts, lawyers and campaign groups. And in doing so, it fundamentally changed how Britain is run. The Human Rights Act incorporated the European Convention on Human Rights directly into UK law. That meant judges were no longer just interpreting acts of Parliament, they were measuring them against an external rights framework. Ministers could still pass laws, but those laws could now be challenged, delayed or even neutralised through litigation. This is where the paralysis began. Suddenly, every decision carried legal risk. Deportations became court cases. Prison management became a rights issue. Border enforcement became a balancing exercise. Policing decisions were second-guessed through legal lenses designed for peacetime, not real-world enforcement. The effect wasn't theoretical, it was practical and immediate. Home secretaries discovered they could announce tough policies only to be blocked by injunctions. Criminals avoided deportation through last-minute claims. Public bodies became obsessed with compliance rather than outcome. Decision makers learned one lesson very quickly: doing nothing is safer than acting. And that mindset spread everywhere. The Human Rights Act didn't just protect individuals. It empowered a permanent legal industry built around challenging the state. NGOs and advocacy groups and especially law firms learned how to use the Act as leverage. Policy wasn't debated in Parliament anymore, it was contested in courtrooms. This created a fundamental imbalance. The public could vote, MPs could legislate, but unelected judges and legal campaigners could still reinterpret or undermine decisions without ever facing voters. Supporters of the Act argue this is the point, that democracy needs limits. But here's the problem. When limits become so expansive that enforcement collapses, democracy stops functioning. Take immigration. Britain has laws on the books. Parliament votes on them, governments promise enforcement. Yet, again and again, removals fail because of human rights claims. Sometimes they are serious, often they are procedural. Either way, the result is the same: paralysis. The state knows what it wants to do, or simply can't do. The same pattern appears in policing. Officers hesitate, forces over-document, criminals exploit technicalities. The focus shifts from maintaining order to managing legal exposure. Morale drops, public confidence collapses. This isn't because police don't care, it's because the system punishes action and rewards caution. And here's the key point most people miss. The Human Rights Act didn't make Britain more humane, it made it more managerial. Decisions are no longer moral or political, they're legalistic. Everything becomes a process, responsibility dissolves. Ministers hide behind the courts, courts insist they're only interpreting the law, lawyers insist they're only defending rights, and nobody takes responsibility for outcomes. That's how you end up with a country that feels ungovernable. This is why attempts to reform or replace the Human Rights Act are always furious and chaotic. The Act isn't just a law, it's a power structure. Entire careers, institutions and reputations depend on it. Any challenge is framed as an attack on civilization itself. But asking whether a law works is not extremism, it's governance. Britain now operates under a framework where the state must justify itself constantly. But those obstructing it never have to justify consequences. There is no cost for failure, no accountability for paralysis, just endless litigation and moral posturing. And ordinary people pay the price. Victims see offenders protected, communities see enforcement fail, taxpayers fund legal challenges that undermine their own laws. Trust erodes not because people reject rights, but because they reject a system that can't act. The uncomfortable truth is this. A state that cannot enforce its own decisions is not fully sovereign, and a democracy that cannot act on its will of its voters is not fully democratic. That doesn't mean abandoning rights, it means restoring balance. Rights without responsibility create disorder. Law without enforcement creates cynicism, and morality without accountability becomes theatre. The Human Rights Act was introduced with good intentions, but intentions don't govern countries. Consequences do, and the consequences have been 20 years of drift, delay and denial. If Britain is ever going to function properly again, it has to confront this honestly, not with slogans, not with fear, but with the courage to say a law that paralyses the state is not working. Until that happens, Britain will remain stuck, governed by process, constrained by litigation, and able to act whenever it matters most. Thanks for watching, guys. If you want more honest political commentary and don't want to miss what's really happening behind the headlines, hit that subscribe button and drop your thoughts in the comments below.